The defense attorney calls to ask me whether I would let him out of the case, or I should say his client out of the case. Do I do it just because he calls to ask me? You want to know the answer? Come join me on this walk on this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Take a look at where I am. I'm shooting video on a deserted island here in St. Martin. And if you look in the distance, let's see if I can get that, my wife is in the background picking seashells. So I have a few minutes to share this great information with you. All right, so now here's the question. The defense attorney calls me up. It's a medical malpractice case. You sued your doctor claiming that your doctor was careless and that his carelessness caused you harm and injury. And now your doctor denies all of your allegations. So at some point, the defense attorney picks up the phone and calls me and he says, listen, I'd like you to let us out of this case. And I say, why? And he begins to explain how his doctor did nothing wrong, how his doctor had very little or no involvement in this particular case and didn't cause or contribute to your injuries. Do I simply turn around and say, okay, no problem, just because you're asking, I'll be more than happy to go ahead and let you out of this case. So sorry to inconvenience you and your client, not a problem, just send me the paperwork and I'll let you out. The answer is, no, that's not how it works. But you should know that there are many times where the defense attorney will call us up and say, listen, my client had no involvement in this case and did nothing to cause or contribute to your client's injuries. I don't see any reason, I don't see any possibility that you can keep him in the case and show that there's liability against my client. In that instance, I may turn around and say, you know what? You may be right, but I'd like you to prove it to me. And the only way that they can really prove it is by doing a deposition. Now, deposition is nothing more than a question and answer session that's given under oath, and it takes place in the attorney's office, the doctor's attorney's office, right? There's no judge there, there's no jury there, but this is really pretrial testimony. And now it gives me the opportunity to ask the doctor questions about what he did and why. Why did you do certain things, doctor? Tell me, what is good medical practice in this instance? What should a doctor be doing if a patient complains of the following things? I need to know exactly what this doctor did, why he did it, what his motivations were, and what his understanding was of good and accepted medical care. Only then will I have a better understanding of whether or not this doctor has liability and whether or not this doctor should or should not be let out of this case. Now, I will tell you there are instances where a doctor has been sued. Initially, we believe that, yes, he had significant liability in the case. However, certain facts come to light during the course of the litigation. Now we learn that this doctor really didn't have much involvement at all. In that instance, if the doctor truly had no involvement or didn't cause or contribute to the injuries, then I will run it by my expert and have him review the transcript to give me a final opinion about whether or not he believes this doctor is culpable. If my expert confirms that there's no way to prove liability for this particular doctor, then there's no reason for me to continue this doctor in this lawsuit. In that instance, I will go ahead and tell the defense attorney, sure, I'll let your client out and continue the case against the other defendants. So that's typically what will happen when the defense attorney calls and says, hey, listen, would you consider letting my client out of the case? He did nothing wrong here. And you know what I say? I say, prove it. So why do I share this quick information with you? I share it with you because it is a gorgeous day today here in St. Martin. And since my wife is busy picking shells, I have a few minutes to share this great information with you. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.